Caught in the crossfire, NAR, DOJ. What's the future of real estate with all this stuff going on? Welcome to episode 5 of Inside the Deal Through Michael's Eyes, a fresh take on real estate and business combined. My name is Michael Renick, and I am your host for this podcast. After a 31-year career, I retired from General Motors at the young age of 52 and moved right into my building my real estate career. I currently hold a Florida real estate broker's license, and I focus on serving Florida's West Coast. The podcast contains both my GM business and real estate experience and goes beyond the surface, offering a candid look at how business should be done right, whether you're navigating the complexities of real estate or tackling broader business challenges. There's a right way to do business in my mind, and it's not always the way that it happens. Education is one of the main goals of this podcast. What I'd like to do right now is introduce a great friend of mine. His name is Michael Hankin, the man I call a powerhouse of legal insight right here in Sarasota. With a deep understanding of the legal landscape and a commitment to helping others navigate complex issues, Michael brings a wealth of knowledge and a fresh perspective to our discussion. You're not going to want to miss what he has to share. Michael, welcome.
Thanks, Mike. Great to be here.
How are you doing today?
I'm doing great. I'm really enjoying the changes going on in our real estate environment, and it's keeping me on my toes for sure, keeping the whole industry on its toes, and just doing great.
Enjoying the changes. See, I probably would pick another adjective.
And it's challenging for certain. The industry and the market's changing really every day with the various changes to the settlement agreements, the Department of Justice's opinion and statement of interest on them, and it's being reinvented. And to me, that's exciting and interesting, and creates opportunities for brokers who stay on top of these changes to really provide value to their clients.
Well, I'm confused. Let me do a little summary of timeline and where I've got it wrong. Correct me, okay? So there was a class action lawsuit, and there was a settlement between NAR and the folks who brought the class action lawsuit. You see, I'm going to talk in non-legal terms here. I'm sure there's names for all of that. But in August, NAR issued and implemented the changes that weren't to be agreed upon by a judge until November. So we made changes that hadn't been agreed upon by a judge. November came, the agreement was solidified or agreed upon, but the DOJ, the Department of Justice, has problems with it. Is that a fair summary of where we are today?
It is.
I did pretty good for not rehearsing that. I like that.
You know your stuff. So it's interesting. This is a class action lawsuit. And in any sort of class action lawsuit, there's always the requirement that the judge sign off on whatever settlement agreement is proposed. And that's to make sure that all the class participants are treated fairly. And so there was a settlement agreement first proposed back in April, which the parties preliminarily agreed upon. And then there was a second preliminary approval of that settlement agreement in August. And then a final approval of that settlement agreement by the court just a week and a half ago on November 26th.
And since then, so everything we talked about, where does the DOJ, the Department of Justice, fit into this overall equation? I haven't heard you mention them in this whole timeline kind of a thing.
Sure. So let's go back one step. The case itself is an antitrust case. And when you think of antitrust, you think of the government getting involved and saying this is anti-competitive behavior, and the Department of Justice coming in to stop what they consider anti-competitive behavior, whether it's methods of unfair competition, whether it's price fixing. There's also in those laws a private course of action. So if one individual or company feels like the antitrust laws are being violated to harm them, they have a private cause of action and can sue the other party that they claim is violating those laws. And that's what we have here. So in the big class action lawsuit that's been settled now, the Department of Justice is not a party. This was a suit by private individuals who became a class that sued the National Association of Realtors for engaging in what they claim is anti-competitive behavior. The Department of Justice has just been sitting along on the side, not involved in the case whatsoever. The Department of Justice has had its own investigation that it's doing into NAR, and there's some suits and some things going on with that, but that is completely outside of all of the practice changes in this lawsuit that we've seen.
So I never want to get political on these podcasts, but I'm going to ask a question this way. There's a change in the leadership coming in January. You'll have new folks in charge of the Department of Justice. Could the new department take a completely different stand than the current Department of Justice is doing? I mean,
yes.
There's different folks going to be running the Department of Justice at the end of January, right?
Yes. So that is possible. I think it's unlikely.
Okay.
I don't think the executive branch likes to dabble that much into what DOJ does. I think they strive and are typically successful at being a relatively independent arm. So
I'm just thinking there's a new person going to be in charge, right? The new administration will change leadership. So I didn't know if that would put a different stamp on it. But let's come back to where we're at today. So what's the DOJ's biggest concern with the settlement that just occurred?
So the Department of Justice issued what's called a statement of interest in the actual lawsuit. And what a statement of interest is the DOJ saying, hey, we're not a party to this suit, but here's our opinions on it. And the Department of Justice said, we don't believe that your settlement in the suit resolves the antitrust concerns that we as the federal government have. So although you private parties, people suing the National Association of Realtors and the National Association of Realtors, have resolved your dispute and come up with a settlement for your dispute, that does not resolve DOJ's concern with your anti-competitive behavior. And we can continue with our investigation. We can continue with it at whatever remedies the DOJ may want to impose. And specifically, they said your buyer's agreements that is mandated by your settlement agreement is anti-competitive by itself. They feel that the buyer's agreements put limitations on how buyers are allowed to contract with their agents. That settlement agreement is essentially, well, it says quite plainly, you have to enter into an agreement with your agent. You have to enter into that before your agent shows you any property. That agreement has to say how much you're getting paid, specify your compensation. And they've just clarified it to say that you can't have amendments to that agreement once you know what the seller's compensation is. And DOJ is saying, hey, you are limiting the way people are allowed to compete. You're putting these rules into place, which have the effect, according to the DOJ, of stifling competition.
So I don't understand. And I'm going to be facetious with the next set of examples here. Most of the brokers that I've talked to over the years before this even became an issue taught their agents to get their buyers to sign a buyer's agreement right up front. They taught that was the best way, just like when we take a listing, we get a listing agreement with the seller, we should do it with the buyers. I've been opposed to that from day one. Where I'm confused is when I walk into a car dealership, they don't put an agreement in front of me at the front door and say, sign here, even if you go to my competitor and buy a car. And that's what the buyer's agreement does. And when I walk into Walmart to buy toothpaste, they don't meet me at the front door with an agreement that says if I go to Kmart, if I could go to Kmart and buy toothpaste, I'm going to come back and pay them. In fact, I can't think of anywhere right up front where that's put in place. But we're taught as real estate agents that we need to do that. And I think that's hogwash. And I'm going to get on my soapbox for a second. What I've always taught my students that I've coached, what I've always taught my agents is you have to earn the right to work with that buyer. And you do that through trust, through honesty, through hard work, and through a lot of other things. And most of the time, if you treat the buyer the right way, they're going to be loyal to you. And you ask for the loyalty right up front. You explain it's a two-way street. I'm going to give you this level of service. I would ask in return, if I drop the ball, please let me know so I can fix it. That's always been my approach. And then all of a sudden, out of this process, I'll call it a process, this lawsuit, we were forced to do that. And there's 4 different agreements in Florida that we can use. And you and I have spent a lot of time going through them. And I built a web page that details them and all that kind of stuff. But it tries to lock the buyer in. So I've been opposed to that from day one. So I guess, I don't know if it's ever happened before, but the DOJ and I are aligned on that issue. Personally, I think it's wrong. So are there, into soapbox, apologize for that. There's a right way to do business. And that's what this podcast is all about. They teach in real estate, you got to use certain words to try to trick people into doing things. I think trick is the wrong word, but I've never bought into any of that kind of stuff. You do business through openness, through transparency, through honesty, and through plain old fashioned hard work. And we've proven that since 14 years I've had a license, and we built a successful business. The stats were just provided to me the other day, and I believe on Longboat Key for the number of units in 2024, I'm number 5 in terms of units sold. So something is working right here. Again, I said I would get off the soapbox, and I didn't do that. I'm passionate about the right way to do business, and it's understanding how to read an org chart. I think 31 years at General Motors, I had to learn how to read an org chart, and your customer is at the top of the org chart. You report to the customer. So anyway, with that said, so the DOJ is not happy with the buyer's side or the buyer's agreement. Are there other things that DOJ is concerned about at this point, or is that the predominant one?
That's the predominant one. The DOJ carte blanche said, we're not endorsing this settlement agreement. We don't think this resolves the anti-competitive behavior that we think exists in the real estate market that needs to be addressed. And they only really particularly called out the buyer's brokers agreements as the thing needing the most amount of change, and that they were specifically against.
So where does this go from here? Are we as agents still in limbo, still at risk because we're following NAR's, the direction we're following right now? Even the fact that we do a buyer's agreement and we can change it after we find out what the seller's paying, that's NAR direction. Is that correct?
It is. So NAR is bound by the settlement agreement that they've entered into. And the DOJ thinks that that is uncompetitive. So we have, I think, a looming battle on the horizon. We have DOJ saying, we don't like the way you guys do business. We think that needs to change. And to date, we don't really know what that looks like in DOJ's mind. What would have been great to have occurred is if the DOJ was more involved in this lawsuit. If the NAR's counsel in the suit got DOJ involved, discussed with DOJ what would a resolution which satisfies your anti-competitive concerns look like, and then incorporate that into whatever deal they could make with the plaintiffs. But here, they've agreed to things which are not agreeable to DOJ. So we know we have a new fight coming up. And what those changes look like after DOJ gets a hold of it is anybody's guess.
I'm going to ask a question that I already know there's no answer to it, but I've got to ask it anyway. How long will this take to unwind and get us to the new finish line?
A while. Nothing with the court systems generally happens quickly. Even federal court, where these cases are, which tends to be more expedited, is still slow in these huge cases. So the NAR settlement, I think, was $418 million. There's a lot of different people who have interest in that. That took years to resolve. The DOJ's case has been going on for over 2 years now. And they have a case currently pending in DC, where they're working through that, and it's on appeal. And it's going to be, I would guess, another 18 months before we get any sort of real new guidelines and guidance from the DOJ as to what they think is truly anti-competitive, and more importantly, how to put their way that they would like to see the industry change into practice. Because it's one thing to say, we think what you're doing is anti-competitive. It's a completely another thing to say, we think you should do it this way. And when you do it amongst private parties, like has just been done, it's guesswork. So the plaintiff and defendant came up, NAR and the plaintiffs in this case, came up with what they thought was the answer to the non-competitive behavior. But they're not the final say on it. DOJ is really the final say on it.
Is the DOJ indicated any problem with the fact that commission is no longer advertised in the MLS, the buy-side commission?
So I think they like the fact that buy-side commissions are not in the MLS, but they have commented on the fact that that information is still potentially publicly available, that it still can be advertised elsewhere, it still can be given to a buyer. They feel like there is incredible pressure, and they put this in their statement of opinion, or statement of interest, that a seller offer 3% to a buyer's agent. And even without that being in the MLS, they find real fault in that. And practically in the marketplace, we see buyer's agents who steer their clients towards the properties with the higher commissions. And 3% has, for better or worse, basically become the standard that we've seen. And buyer's agents help to steer it that way. Rightfully or wrongfully, I think that's a practice that we all have observed in the marketplace. And DOJ really doesn't like that. What they would propose to change, I don't know. They might say, listen, seller's agents, you can no longer compensate buyer's agents. And seller's agent will be compensated by the seller, buyer's agent will be compensated by the buyer, and that'll be that.
So what a concept, right?
Right. And you pay the person who's working for you.
So, for example, let's use a legal thing. Let's say I get charged with a serious felony, completely innocent, but let's say I get charged. I wouldn't expect the prosecuting attorney to pay my attorney that I hired to represent me. Is that correct?
That's correct.
If I go into Walmart to purchase something, I wouldn't expect Kmart to pay for that.
I wouldn't think so.
And I apologize for using a company going out of business, but I can't think of another analogy right now. It just, the basic part of business again. When you represent a client, you don't pay the other client.
Absolutely not. Right.
Car dealers, when I go get a haircut and I pay the barber, he doesn't pay someone else, kind of a deal. So, excuse me, just plain business. If we come back to the basics and we peel away all the covers we've operated under in all these years, to me, it seems the fairest is the seller pays for the seller's agent, the buyer pays for the buyer's agent. And it makes it clean. The ruling was really good because the concern was sellers paying buyers, agents. That's what I've heard from day one. And the ruling didn't change any of that. It just said where you can't print it. I like how we don't solve the root cause of something. We dance around it. So there's a lot of different ways that I can, if I have a listing, I can now still legally advertise and share what my seller is willing to pay. I just can't put it in MLS. So that didn't, in my mind, fix any of that part of the issue. And like I've shared throughout this podcast, I have a big problem with the buyer's agreement. I think you should, having to earn the trust of your client. I mean, again, what a concept. In other words, as an agent, we have to work hard. And that's what we've always stood for here. But this is taken a level of complexity and put it on top of it. It's made it confusing. You have spent an inordinate amount of time making sure that I and my team understand what the law is. And even in terms of, as this was rolling out, we had many weeks to prepare and training. Things were changing during that time frame before the final agreement came out. And what I'm learning right now is we're not done yet.
It's true. And 2 weeks ago, the industry practice was get a buyer's broker's agreement signed, go to the seller or seller's agent, find out how much compensation was being offered, and then adjust your buyer's broker's agreement to essentially match that. Now we found a week and a half ago that is not allowed. And that was everyone's take on it 2 weeks ago was that's essentially how you do business. So buyers were signing 1% agreements with with their agents, finding out a seller was offering say 3%, going back to their buyer and saying, hey, we need to adjust our agreement to go up to 3%, the amount the seller's offering. And that really was industry standard. They've come out with standardized forms for that to happen because everyone said that's how it's going to occur. And a week and a half ago, in the settlement agreement finalization, they clarified that absolutely not. You're not allowed to change your buyer's broker's compensation once you know how much the seller's offering. And now we have all sorts of new ripples as to how to incorporate that into what we do every day. And that's why it's exciting and interesting to me is this really is, I don't want to say being made up as we go along, but that's the best term for it because it's changing and nobody knows what it's going to look like in a week and a half from now.
So today, NAR's direction is we can modify the buyer's agreement. Is that correct?
NAR has not, to my knowledge, updated its recommended practices since the clarification to the settlement agreement a week and a half ago. So I'm expecting new guidance to come down from NAR to say, no, what we told you could do before, you can't do anymore.
So I'm going to tell it like it is, kind of a guy. You just threw a softball up there and I've got to hit it out of the park. You said NAR's recommendation hasn't changed. Was it or was it not NAR's recommendation that got us into this quagmire in the beginning?
Sure. NAR's essentially told us how to practice, what to do, how to interact with people, what's allowed, what's not allowed. And we are all the unfortunate, I don't know if I'd call us unintended or intended bystanders of NAR's actions. And I'm very disappointed in NAR for not working more cooperatively with the Department of Justice to come up with a more complete solution, to get rid of this claim of anti-competitive behavior once and for all. I think the realtors generally have they've gotten some bad press throughout this whole lawsuit. And everyone makes mistakes. Everyone can go back and look at their processes and say, hey, this might not have been the right way to do it. It's been called to our attention. We're examining it. We're fixing it. And I think NAR's failed in that. I think NAR has done what they needed to get rid of the lawsuit, but not done what they've needed to resolve the issue. And as a result, we have more uncertainty in the market and more change, more new practices, which take a while to be implemented for people to understand, and it causes disruption. And at the end of the day, that hurts buyers and sellers of real estate, who everyone should be most concerned about. That's who realtors are there to serve, and that's a huge component of our economy, close to 1/5 of our overall economy. And we need our government and our institutions to work to make it work.
See, I think you hit the nail right on the head. This whole process, if I can call it a process we're going through right now, it's taking the eye off of what realtors really do. There's all the comments where realtors and used car salesmen are thought of at the bottom of the food chain, kind of a deal. But most of the realtors that I've met, most of them that I work with, are hardworking. They're honest people. They want to do the right thing. They're interested in either getting a property sold for their seller or helping their buyer find that perfect home. And none of this stuff that we're going through right now helps in that process whatsoever. Would you agree with that?
I'd agree. In practice, I think we've seen that commissions haven't changed. We've just all gotten one additional piece of paperwork, and nothing has really changed. And if they wanted to do something, they should have done something. To go through all of this, pay the attorneys 60, $80 million in fees, have a $418 million settlement. And at the end of the day, our lives look the exact same with just a couple more pieces of paper. It is a travesty. It's a waste on the whole system.
It doesn't add any value to the ultimate objective of either the buyer or seller. That's the sad thing here.
That's right.
And we need to get to the finish line, whatever it is. And personally, I hope they throw away the buyer's agreement. I've never liked that. Every time I have an agent now getting ready to go out with a new buyer, I have to ask that question: do you have the buyer's agreement signed? I've never asked that question before. In fact, I won't say I forbid my agents, but I highly encourage them not to use a buyer's agreement in the old days before this happened. And I taught them how to build the trust, just like a car dealership, your barbershop, your attorney, all those kind of things. So I don't know. This is just confusing. I think it's important we keep talking about it. That's why I wanted to do this podcast with someone with your outstanding background in this field. We somehow got to figure out how to get this thing behind us so we can go on and do the right thing. To me, simple things in life don't happen. And being an old man, I figured that out a long, long time ago. The simple thing is the seller pays for their agent, the buyer pays for their agent, and we all move forward. But if we get to that finish line, it's going to be a long time, like you said before.
I agree. And I think what makes the most sense is exactly as you're saying. You hire the person you want to hire, you negotiate the amount you want to pay them. That person works for you, and that's that. And there'll be true competition there. You hire the barber or your yard service guy or whoever it is based upon the job that they do for you and what their performance is. And it should be the same for realtors. You want to hire an agent who's going to do a good job for you based upon their past performance, based upon what you've seen them do elsewhere, based upon their value proposition. And DOJ, NAR, and everyone else should help us get there because it's good for everyone.
I can think of a lot of comments I'm holding back in terms of my opinion of the value. In the years I've had my license, that NAR has really helped me succeed as an agent. What was interesting is I sit down with an 18-year-old young man over the weekend who wants to get his real estate license. And he was asking advice. And it brings that conversation back because, when you get your license, you have to memorize for each different level, whether it's pre or post, it's agent or broker, how many hours you have to set in the classroom. Of course, I don't remember that number, so we looked it up. So a new agent for the pre-licensing in Florida has to set for 63 hours. And so he started to ask, what are some of the things he's going to learn in there? Well, what are the things he's going to learn to help him be more effective as a real estate agent? And I candidly said, absolutely nothing. You're going to have to memorize of the FREC, the Florida Real Estate Commission, how many of the, first of all, how many brokers have to be there, how many non-brokers, how many, it just, and then my ideal thing, I really got to go off on this and I apologize. So when I set for my broker's license, I was excited because in the old days, we had to do closing documents. And I love those kind of things because you come to one right answer. And I like that. And before I set for the test, I learned they took that off because too many agents were failing. So that's one problem. Because something's difficult, you don't remove it. You train, you educate better. But what I love, what's even more ridiculous, is when I set for my exam of the 3 or 4 page, I don't even remember how many pages anymore, but 3 or 4 pages closing documents, and they were called HUD in the old day. Now they're called closing documents. What page is the insurance adjustment on? What page is a property tax adjustment? I've never, that I can think of, heard of anything more ridiculous than having to memorize a page number for an adjustment, because when we're working through that, we have the form in front of us and I can look up each single page. So, but this is the value. This is why I'm back on the soapbox. This is the value that I see coming from these organizations, and I see it bringing no value whatsoever to me succeeding or failing as a real estate agent.
I agree. And there's a ton of changes that could be made to the licensing requirements to make the agents that much better. You look at well digging licensing, for instance, in Florida. If you want to become a digger of a well, you have to apprentice with somebody else who's dug wells for many years, and they supervise you. They are your mentor. They teach you what to do, and then they have to sign off that they've done a good enough job and have enough experience to do it on their own and get their own license. Same thing's true with surveyors, engineers. But you take professionals who are buying or selling somebody's most important asset and you let them loose on buyers or sellers after a 63-hour online class you could do in a week and a half. It's really, there's a huge issue there. And we've seen here locally, it was close to 100 agents getting licenses back in the heydays each month. And these are people who, by definition, have no experience buying or selling or anything else. And our laws just allow that online class, zero experience. And that person is now the key person helping a buyer, maybe a first-time buyer, purchase their biggest asset, incur their largest liability, and is in the United States the biggest generator of wealth for people. And it's, I think, a travesty that there's not a greater experience requirement, not a greater education requirement, let alone the content of the education. Like all things, you learn by doing, and sitting in a class is never going to be enough.
True or false? When an agent graduates from their pre-licensing class, do they know how to fill out a buyer's offer?
Oh, absolutely not. It's a perfect example, Mike. You don't see, so in Florida, there's no mandated form for purchases and sales. There is a form that's very commonly used, put out by the Florida Association of Realtors and the Florida Bar Association in a combined effort that has gone through a ton of revisions, is used most commonly. And as an agent with your required education, you never see that form. You might not know that form is even a thing if you decide to.
Wouldn't you agree that's one of the most forms we touch as a real estate agent?
Absolutely.
And no training whatsoever.
14 pages of single-spaced documents, and for the standard as is purchase and sale agreement. And yeah, you never see it as an agent until you're filling it out with the client as the requirements for the license.
When I was going, I don't remember if it was pre or post brokers, probably pre, we were talking about leases, for an office. And we were talking about, was it a variable or fixed expense? And I can't remember what the instructor said, but I took the opposite. And I just really dug in. When he countered with something, I would counter with something back. And he stopped for a minute and he says, "Mike, can I just ask you a hard-hitting question?" I said, "Certainly." He says, "I propose you don't really care. You're just bored right now, aren't you?" And I said, "I am. Please help me." Does it really matter what word we put on it? But I mean, they took us some of the things. It was so anyway. We do have to. There's a lot of things we have to change. We have to change the compensation system. We have to change how we educate agents. We have a reputation that's not strong, and we need to hold FAR and NAR and all those folks accountable for the requirements. When I get a license, I should be taught ethical behavior, and I should be taught how to succeed, how to best help a buyer, how to best help a seller, and none of that happens. True or false?
Absolutely true. There's no required ethical training as a licensed real estate sales associate. And if you want to become a realtor, there is some required training, but much of it can be done online. There's a ton that I would change with the way new agents are admitted and taught and become members and get their licenses. Probably for a future show. I don't want to get us too off topic, but definitely there's a lot of problems in the industry that need fixing.
And we have to keep talking as agents, as brokers, as attorneys. We need to push this in the right direction so things are done the right way. Like I said, there are so many high-quality realtors out there, so many high-quality brokers out there, that the rap that many of us are getting is because of this controversy out there. Like going to a buyer right now saying you have to sign this when I've never had to do this in in almost 14 years of practicing real estate. And then it was funny. We were at a coaching session and they're teaching us what words to use. The words I like to use is, I'm opposed to this thing, but I have no choice. And if you don't sign it with me, I get that, but you've got to sign it with whomever. And I get you when you say you're not comfortable. I'm on your side. They don't teach that in an education class or a coaching class, but it's still speaking from the heart. But anyway, I want to thank you for bearing with me. When we planned this podcast meeting, and I've got other examples I could bring up. I've just hit the tip of the iceberg, but that's what this podcast is all about. What's the right way to do business? And we do have to figure this thing out. It's still changing. Is there anything else, Mike, that we should cover before we wrap this thing up?
I don't think so at this point. I think we need to continue to pay attention to it, see where it changes, see how the industry evolves, and only time will tell.
All right, Michael, I want to thank you for being a guest. It's my hope that we will get together on a regular basis. There's lots of things we could talk about. We could take just one of the many objections we talked about on this, and we can make a whole podcast out of it.
Absolutely.
And we could talk about the right way to get things done in the real estate business and things like that. So again, thank you. I enjoyed the opportunity to spend time with you. Every single time we're together, I learn, and I want to thank you from the bottom of my heart for that.
Glad to be a part of it. Thanks, Mike.